So welcome, everyone, to the first Constitutional Law Center event of 2026. Not much has been going on recently in constitutional law, so we decided, maybe to devote tonight to more foreign things. This is actually, I think of this as a rapid response program because, as you know, over the weekend, there was, what do we call it, an attack? That's what I called it in the, on the brochure. I was in class con law this morning. We were talking about the Korean War. Harry Truman described the Korean War as a police action. So who knows what we call this. But in any event, it's my pleasure to have been able to welcome two people whose perspectives are invaluable on this topic. My friend Jack Goldsmith to my left here, professor, the learned hand professor, which is very impressive, at Harvard Law School, is, I think, our nation's leading authority on the constitutional law of national security. He happens to be here at Stanford for this 2 weeks, and so we muscled him over to the law school to join us for this program. And then coming in from Zoom is my friend Juan Miguel Matheus, who is a former fellow here at the Constitutional Law Center, still an affiliate with the center. He is a professor of constitutional law at a university in Caracas, and also has been since 2015 a leading opposition member in the legislature in Venezuela, but for reasons that are probably obvious, can't actually be in Venezuela at the moment, and is currently a fellow at the University of Texas. And I guess right now, Juan Miguel, didn't you tell me you're in Puerto Rico? I'm hoping that means that you're contemplating a move a little bit south from there, but maybe you'll tell us about that. But in any event, we're dividing the topics today, and Jack is going to address the legality from an American and international law point of view of the Trump administration's action in Venezuela, and then we're going to hear from Juan Miguel about the perspective, from the possibility of restoration of liberal democracy in Venezuela. Is that going to happen? What are the developments? How do things look from a Venezuelan point of view right now? So I'm now going to turn it over to Jack.
Thank you, Michael. Thank you all for coming tonight. As Michael said, I'm going to discuss the legal issues related to what I will call the invasion and what the government called it, apprehension operation against Maduro. I'm going to divide it up into international law first and then domestic U.S. law. This actually is a constitutional issue, Michael. Does the president have the constitutional authority to use U.S. force in another nation and U.S. law enforcement in another nation without congressional authorization? So there is a constitutional issue lurking here. But let me start off by saying that the legal constraints on the use of force, both internationally under international law and domestically under U.S. law, are not what I would call robust. They under international law, as I'm about to discuss, they sound robust, but there's no effective enforcement mechanism, as I will explain. So let me get started. So the international law framework is governed by the United Nations Charter, which is the closest thing there is, I suppose, to a constitution of international law. International law is the law that governs, I'm talking about public international law, the law that governs the relations between nations, including the foundational idea that each nation is sovereignty and that their sovereignty is sacrosanct. The core principle of the UN Charter, a core principle of the UN Charter, is in Article 2, Paragraph 4, which prohibits the threat or use of force against the territorial integrity and political independence of another state. Let me say that again. It prohibits the threat or use of force against the territorial integrity or political independence of another state. The United States violated that provision last Friday. There's no doubt about that. There was a clear violation of the UN Charter. There are two possible defenses or two possible loopholes. One is Article 51 of the Charter allows nations to exercise self-defense, and the United States has interpreted this self-defense power very robustly, but I see no conceivable basis for arguing that self-defense was warranted here under international law. That's the first loophole that I don't think is exploitable here. The second one is, and I actually expected the Trump administration to invoke this, and I suspect they might still at some point, and that is it's not a violation of sovereignty, of another nation's sovereignty, if you are invited in or if the other nation consents to the use of force in the nation. And I half expected the administration to say that some member of the government that it recognized as the official leader of the government had given consent and had invited the government in to engage in this operation, but there's been no hint of that argument yet. And every day that goes by makes it less likely that it will be invoked. So, I mean, I join practically everyone who's looked at this in saying that this operation clearly violated the UN Charter. What is the remedy? There is no remedy. The UN Charter itself has a remedy of sorts. It authorizes the Security Council to authorize the use of force to maintain the peace, and sometimes the Security Council has authorized nations to use force to stop an aggression. But of course, the United States has a veto on the Security Council, so that's impossible. And that tells you a little bit about the realism of the international law of the use of force. So there's no effective remedy for this international law violation. Now to domestic law, which is a little bit more interesting and complicated. So this is, I'm going to try to explain in simple terms the rationale that the government has given in bits and starts, but this is clearly what they think was the justification for the use of force. The argument is that Maduro and his wife were indicted by the United States and violated U.S. criminal law through drug importation and trade, and that acting in Venezuela, they acted in a way to cause harm in the United States that violated U.S. criminal law, and therefore the United States was engaged in a law enforcement action to arrest someone who violated U.S. domestic law. There is a Justice Department opinion from 1989 written by former Attorney General, then head of the Office of Legal Counsel, William Barr, that made the case that this was lawful, that that U.S. criminal laws applied extraterritorially, and that the FBI had the authority, and that the president had the authority to order the FBI to go into another country and arrest someone and bring them back here. This is not the first time this has happened, or the second, or the third, or the fourth. But what about the use of force? So that's the justification for going in, violating the other nation's sovereignty, and snatching Maduro and his wife. What about the 50 people who were killed and the bombs and the U.S. military forces on the ground? The justification there, and I'm just describing to you what the government has said, is that the United States was acting in self-defense of those arresting officers. And so this seems like an odd argument to say that you can violate another nation's sovereignty with law enforcement officials and then use the military to exercise self-defense so that they're able to effectuate the arrest. If that sounds like an imaginative argument, it is, but that was the argument. Then there's the question of why can the president violate international law? Isn't international law, especially the UN Charter, a law of the United States that is binding on the president? There's Article 2 of the Constitution, gives the president a duty to take care to faithfully execute the law. The treaties are laws of the United States. They're supreme. Article 6 of the Constitution says they're supreme over states. They can be part of federal law. So why can the president lawfully violate the treaty? The answer to this question, and this gets a little technical, I apologize, and I'm just going to be very general, and I'm happy to follow up during the question and answer if you like. The answer to this question is that the United Nations Charter is not considered what's called a self-executing treaty. And the Barr memo explained that since it wasn't a self-executing treaty, it wasn't binding as domestic law is binding on the president, and therefore that the president could disregard this treaty without violating domestic law since this treaty was not binding on him. That argument, which was somewhat tenuous at the time and has never been squarely held by the Supreme Court, but it received a great boost in a case that came out after Barr wrote this memo, but before the snatch, in a case called Medellin, where the Supreme Court, in a different context, suggested that indeed the UN Charter as a non-self-executing treaty wasn't really domestic law that was binding domestic law. So that is basically the legal rationale. The international law argument is clear. It's clearly violative of international law. I actually think, as crazy as it sounds, that there are powerful precedents, Justice Department precedents and judicial precedents to authorize this. I expect that Medellin, and I'll end here, Maduro will, he will certainly make challenges to all of these actions. The precedents are the Noriega case from 1989, which looked very much like this case. It was a U.S. operation abroad using military force in a kind of law enforcement action to grab a head of state and bring them back here for violating U.S. law. All of those issues about the legality of the snatch, whether it precluded the trial, whether Noriega had immunity, all of those issues were fleshed out in the Noriega trial in the 1990s. All of those issues will come back again, and I expect that the government will prevail on those issues in the domestic realm.
Juan, Miguel, thank you very much for being with us.
Thank you, Professor McConnell. Well, thank you so much for the invitation to this first activity of the year of the Constitutional Law Center. It is an honor for me to chair this panel with Professor Goldsmith. And I would like to start by saying that I'm Venezuelan, and I'm a Venezuelan politician. So you may know that I'm happy because what is happening right now in Venezuela, and I'm happy because of what could happen in the future, in the near future in Venezuela. After 27 years of an autocratic regime, we have done everything in the country to get our democratic liberation. Demonstrations, referendum, elections, all according to the Constitution. So it is not easy to me to talk about the legality of the action. So I will tell you something about what I think is the state of the art right now, the current political situation. I will tell you something about the challenges of the democratic opposition in Venezuela, and I will tell you something about the constitutional framework to resolve or to solve the problems of the current political situation. So, regarding the state of the art, I would say that the situation is this. We have a partial democratic liberation, and I think that the exact term for what happened last Saturday in Venezuela is an extraction of the president of the republic. So we have a partial liberation through a partial rupture in the regime under right now an international tutelage, and with a part or the apparatus of the regime still remaining of power, and the head of that apparatus is Delcy Rodriguez, who is supposed to be the vice president of the republic, but she's not a legitimate vice president of the republic since she was appointed by Maduro, and he wasn't a legitimate president. And what is concerned, is worry, is that the democratic opposition is marginalized of the current situation right now. So we could face a situation that is unknown for everybody. The elements of the possible democratic transition in Venezuela challenge the political science, challenge the categories of the third wave of democratization. We are facing the unknown. So, and regarding the challenges of the democratic opposition, I would say that we have to face this situation with the Constitution. We have to embrace the Constitution and to face the remaining part of the regime in power with the Constitution. And also, we have to face another countries, the United States, with Trump as president, with the Constitution. So that is the main idea. We have a Constitution, and we have the answers to the crisis in our Constitution. Then we need popular sovereignty. So we need and we want elections in Venezuela because we want the people saying something about the situation, and because we have this tutelage right now by the United States, but we need to put some limits to that, and we need some time limits. So I would like to expect a fair and free election in the next 12 months in Venezuela. Then we need to reestablish the system of human rights, and I would like to propose, I will propose in the National Assembly to invite the Inter-American Commission of Human Rights and the Office of Human Rights of the UN to be present in Venezuela, and then we have to reestablish the diplomatic relation of Venezuela with many countries, including the United States. So, what is the constitutional situation? We have a problem of legitimacy, and we have constitutional provisions for this. So, Maduro was not a legitimate ruler, a legitimate president in Venezuela, but the Constitution has a provision according to which if for any reason the president of the republic is not present in the territory of the republic, so the vice president become the acting president. And the provision established that the vice president will be the acting president during 90 days. And then that acting president can have an extension of 90 more days as acting president. And after that, the electoral power has to call for an election. So according to the Constitution, in the next 7 months, there will be elections in Venezuela. So that is the situation, and let's see what happens. It's too early to tell what is going to happen, but I think that if we have in mind the Constitution and the need of election, we can solve the problem and we can go through a real process of democratization in my country.
Let me start off the conversation by posing a couple of questions, each of them beginning with Juan Miguel. I have heard it said that if the U.S. administration presses too hard in favor of the opposition in Venezuela, that the army will stage a coup. And I don't I'm curious to know what you think of that. What position is the army in? Is it functioning independently? Does it have resources? Can it stand up to the United States at this point? What is the role of the Army in Venezuela?
Well, this is a good question because after Maduro's extraction, it was proved that the Venezuelan military doesn't exist. The apparatus of the regime has not military power to face a threat from abroad in the country. The military power in Venezuela just have repression powers, but the role of the military right now is to wait what is going to do the United States and the proposals of the United States. Because, as I said before, there's no military power in Venezuela. The extraction of Maduro was an impeccable operation, no resist. 80 people died, and among them, 35 people from Cuba, people that belong to the personal guard of Maduro. So I think that the argument according to which the opposition, the Democratic opposition, Maria Corina Machado, should be put aside is a cynical argument because the military forces don't play the role that they say they have to play.
Let me ask another question. President Trump has said that we're going to, I'm not sure I can quote the exact words here, but basically that we're going to take over the oil. What do you make of that? Do you understand? Is that bluster? Is this something we should be worrying about? What does it even mean?
Well, the first words that he used were, we're going to run the country and we're going to stay. And then he said that the United States would reestablish its rights of the Venezuelan oil. Nobody knows what does it means and the meaning of that. But right now, the United States is reopening the embassy, the U.S. embassy in Caracas, and of course, all the oil company from the United States and also from other countries are starting a process of negotiation with the Venezuelan regime, with Delcy Rodriguez, to overcome, to create a frame in which the economic sanction could be removed and the investor would go to Venezuela. But it's too early to tell. If you ask me in strictly political terms, I would say that President Trump wants oil independence in the West in case of a high-scale war or in the world.
But just to clarify, that oil independence could be satisfied by Venezuela's own control, perhaps with Western oil companies, but where Venezuela has its own control over its own oil resources. It doesn't necessarily mean what Trump sometimes meant, what he sounded like he might be saying, that the U.S. would take control over the resources. In order, if what the U.S. is concerned about is Western Hemisphere oil independence, we don't have to own that oil.
Yeah, you're right. And my concern is that, this is my personal opinion, my concern is that probably President Trump doesn't want a democratic transition, but a transaction, an oil transaction, where in a situation in which the United States, in a position of superiority, could get some oil resources without control. And I'm pretty much sure that Delcy Rodriguez could be happy with that if she could remain in power. That's the challenge of the Venezuelan opposition. We want the support of the United States, but we don't want the United States to use without control our resources, because it's not just.
And now a question for Jack. You made quite a point of that international law, even if it was clearly violated, as you indicated that it was, has no enforcement mechanism. But you also spoke of U.S. law, including U.S. constitutional law, and I'd like to ask the same question. What's the consequence for violating that? Is there any enforcement mechanism for that?
So, as I said, I think the president has a decently strong argument that, as crazy as it may seem, and it seems a little crazy to me, but this is the state of U.S. law about war powers is extremely underdeveloped. I'm going to answer your question in a roundabout way. It's underdeveloped because the Supreme Court has never weighed in on it, and this is partly an answer to your question. The Supreme Court has always shied away from cases involving presidential uses of force under a variety of doctrines. So let's imagine that I'm wrong, and I might be wrong because there's some novel issues here, and that President Trump exceeded his authority under Article 2 of the Constitution in using force abroad. There are effectively no remedies for that violation either. Just as there weren't remedies for other presidents' clear violations of clear unilateral uses of force that many people thought violated Article 2. There are often lawsuits brought. They're always dismissed on standing grounds, on political question grounds. So Michael's making the point that not only is the international law on the use of force not enforceable, but whatever limits there might be under the Constitution on presidential uses of force, and I want to insist that those limits are quite contested, they are effectively not enforceable by courts. The institution that is supposed to police the executive and enforce constitutional law, the constitutional law of war powers, is the Congress. And the Congress has been supine for a very long time. They enacted the War Powers Resolution in 1973. The War Powers Resolution is not a robust constraint on presidents. Presidents have disregarded it and circumvented it. And if Congress doesn't assert itself vis-a-vis the executive branch, Congress is the only check that there can be. Congress has sometimes done so. At the end of the Vietnam War, in Somalia, in Lebanon in the 1980s, Congress occasionally rises up and says the president went too far and cuts off the funding and says the president can't do it, and Congress can do that in theory, but I don't expect this Congress to do that.
In the Yemen conflict, which we don't read all that much about, but in which the United States has also been involved without congressional authorization, possibly under the authority of the Gulf War authorization for use of military force, Congress did cut off, both houses, Senate and House, together voted to end the conflict, and President Trump vetoed. It was, I believe, his only veto as president, and it was not overridden. What do you make of that?
This shows the challenge that Congress faces. Congress, to stand up to the president in the use of war powers, has to effectively overcome a presidential veto. So that means that for Congress to effectively check the president, given the current state of the law, for Congress to effectively check the president, it has to overcome a veto. Now, there are tools it could use. There's something called the National Defense Authorization Act, which is this huge omnibus Defense Authorization Act at the end of the year, where there are lots of things in there that the president needs and wants, and Congress could slip in some restrictions there, as it sometimes does in other contexts, thus putting the president to the choice of vetoing a bill he really wants to veto a provision of it that he doesn't want. But the president also has other options, such as saying that that restriction is unconstitutional and not enforcing it. So I just want to, it's just very, very hard. Congress has to overcome a veto to effectively stop the president from using force.
Let me invite members of the audience to come down. If you have questions, and I hope and assume you do, come down to the microphones on each side, and please speak clearly into them so that your questions are recorded for those people who will be listening to this over the internet. But while you're coming down, let me just throw one more quick question to Juan Miguel, which is this, that we've been reading statements from high officials in our government that are not all on, they're somewhat discordant. They're not all saying the same thing. President Trump in particular has been focusing on oil and various things. Secretary of State Rubio, who in many ways seems to be running the operation, seems to be sounding a different tune. If American policy were being directed according to what the Secretary of State has been saying, do you think the prospects for a democratic transition would be good?
Yeah, I think that you are right. When you listen to President Trump and you listen to Secretary of State Rubio, it seems like you are listening to two different persons that belong to two different administrations. And President Trump speaks in that rough manner, and then Secretary of State Rubio is much more diplomatic, and he has much more consideration with the democratic opposition of Venezuela and with the Venezuelan people. There is an important fact. He has Cuban roots, and I think that he is a real politician, a professional politician with Cuban roots. And I would say yes, if the policy of the United States would depend only on Secretary of State Rubio, I think that things would be better and we could have more certainty, which is the difficult thing to get from President Trump, to know what to expect.
So now let's have some questions, beginning with Duncan Hosey, whom let me introduce to everyone as the new fellow in the Constitutional Law Center for this year.
Great. Thank you both. This is great. I have a question for Jack about Maduro's emerging defense strategy. Polik, his lawyer, yesterday signaled they're going to make a head of state immunity argument. I'm curious if you could assess the merits of it, how it's different from the one advanced by Noriega unsuccessfully, and how we should think of head of state immunity when you have a leader who isn't recognized as legitimate by the United States and international observers, but has been exercising sovereign authority within a country.
The short answer is these issues aren't settled. So just for the audience, there's something under international law, a head of state has immunity from, certain immunities from process, including criminal process in other states. That's the international law rule. How it applies in the domestic realm is sometimes uncertain. The United States sometimes recognizes head of state immunity for foreign heads of state when they're sued, especially on the civil side. It's different from Noriega. I haven't studied this in a while, but it's different from Noriega because I believe that the government there gave its consent to the trial of Noriega. It's not at all clear that's going to be forthcoming from Venezuela. That would, since the immunity, the head of state immunity is the nation's immunity, the nation can waive the immunity. It's not at all clear that that's going to happen here. Just to answer two more points, the fact that the United States has not recognized Maduro for 6 years, technically, I believe, doesn't matter on the international stage, but it will matter a lot in the domestic realm. The final thing I'll say is that while the Supreme Court has not yet been crystal clear, it has indicated in precedents going back a long time, 100 years, that the executive branch's view of whether the foreign head of state warrants immunity under international law, especially in a criminal prosecution, will receive extraordinary deference. And for that reason, I believe the defense will fail.
Hello. Thank you so much for doing this. I'm interested in the perspective of both you, but particularly from Venezuela. I think as shocking as this was, it was surprising not to see Maria Corina Machado installed, after all of the talk about how illegitimate this government was. What's the view on that in Venezuela? Was that surprising? Is that what people would like to see? Or are they happy to just wait and have future elections? And I'm just starting to learn about the colectivos, and I'm curious your perspective on how they're going to play into the future.
I couldn't hear well, but I think that I understood the question. And the answer is that, of course, that for the Venezuelan people, in general, for the population, was shocking to hear from President Trump that Maria Corina Machado has not the respect of the country, because that is not true. She is the leader of the country, and she's still the leader of the country. We have to remember that she won the primary elections back in 2023 with 95% of the votes. And after that, she was disqualified and she couldn't run for office. So she fostered an arrangement to have elected President Edmundo González as a candidate. So, but I think that not just for Venezuelan was shocking. I think that for all the common sense people, these people with common sense in the international community, was shocking. And probably President Trump wanted, he didn't want to say that she has not the respect of the population, but she wanted to say that that she doesn't have the possibilities to control the military or the territory, which is totally different, because there are solutions for that. But the answer is that the Venezuelan people want Maria Corina Machado leading this process, and of course, that I think that the people is willing to act, to go to the demonstration and to streets to be present in this process.
Yeah, I just have a question about the hydrocarbon assets that.
Could I ask everyone to, when you speak, to speak really into the microphone so that Juan Miguel is able to hear?
This better?
Please.
So I have a question for Professor Goldsmith about the oil and gas or assets that currently exist in Venezuela, specifically those that were seized by the Venezuelan government in 2007. So there seems to have been, since 2007, a lot of arbitration, both in international courts or international parties, ICISD, and in U.S. federal courts, just recently with Judge Lambert awarding damages to U.S. companies for those seized assets. Do you think the awarding of those damages to U.S. companies, like having Citgo pay Exxon, for example, for seized assets, could tarnish claims by the U.S. administration or by U.S. domestic oil companies that they have a claim to assets that exist in the country, or like the president's claim that we're going to take the oil back that was taken from us, or I don't know.
I don't understand the question. I'm sorry. There was a lot going on there. There were expropriations. The expropriations in Venezuela violated international law. There were some arbitrations that were reduced to judgments. Some of those judgments were enforced in the United States. Some of them were, as I recall, invalidated. Okay, that's the state of play. And then what is the question?
The fact that has been, does the fact that has been settled in U.S. and international court or litigated kind of get rid of the argument, or like the president's argument, that we have to
Oh.
take back our oil company?
Well, I don't, so I don't know enough about the details to know that, but I'm pretty confident, although I'm not 100% sure, that not all of the claims have been adjudicated and that there are still outstanding claims for expropriations. You're talking about whether you're asking whether the arbitrations of the claims basically preempt President Trump's arguments that they were stolen.
Yes.
I mean, as a legal matter, it might, but as a political matter, I don't think it will. I'm sure that the arbitrations, they never give 100 cents on the dollar. And as I say, I don't believe that all of the expropriations have been reduced to awards. So I think that'll be a skirmish on the side, but I don't think it's going to. And who knows what he even means by that? I mean, this is what we've been hearing, is that it's not even clear what he means when he says we're going to get the oil that we deserve. Operationally, we have no idea what he's going to claim to do, so it's very hard to know how those arbitration awards will affect that. Sorry, I can't be more specific.
Thank you.
Yes, I'm just interested in what your thoughts are with respect to regime changes. Since 2000, the United States has been involved in regime changes in Afghanistan, Venezuela back in 2002 when there was an attempted coup with the former president, Iraq in 2003, Haiti in 2004, Honduras in 2009, Libya in 2011, Syria since 2011, Bolivia in 2019, and Venezuela just a couple of days ago. Now, if we want to go back to World War II, to the 20th century, where OSS and CIA and President essentially did quite a number of additional situations where attempted coups were and overthrows of regimes were done, the list becomes much larger. I'm just curious, very curious. The President of the United States and CIA have incredible powers above and beyond, at this point, what was envisioned by the founders of the Constitution. And I'm curious what it will take to limit these types of power going forward.
So you left a lot out. I don't know why you started in 2000. You skipped over Kosovo in 1989 and Panama and.
I said since 2000.
No, I know, but then you went back to World War II, and there was a lot that happened in between there. There was the Dominican Republic in 1965, and Noriega in 1989, and Kosovo in 1999. I mean, that's not a legal question. I don't know how to answer it. This is the system. I've been writing about this a lot lately. This is the system we have, and it's not new. We have a system, and by the way, it goes back long before World War II. I mean, the times in which the United States was most rampant in intervening in other countries on a regular basis was in the late 19th century and early 20th century in Central and South America, dozens of times, to change regimes, to foster coups, to foster counter coups. So you could say that there's a very long and robust tradition of the United States doing this since the late 19th century, almost without, just continuously. I mean, you're asking me the question was, what do we have to do to stop this? I would suggest that the democracy is the only entity that can stop it, and that means through Congress. Courts are not going to do this, and I don't expect that to happen. So that's the only answer I can give.
Professor Goldsmith, you spoke descriptively about whatever limits there may be on the president's war powers, but normatively, what constitutional limits do you think there should be on the president's war powers?
That's a very difficult question. I guess I believe that the president, I'm going to give you a 1-minute answer to something that can't be given in 1 minute. I am of the view that the president, the whole theory of democratic control over the use of force is that the way to ensure that wars serve the national interest is to have a democratic check and approval on those wars. And something like that was clearly the founders' view, whether it was because they thought the Declare War Clause meant Congress had to authorize it, or whether it's because they thought that the presidents couldn't use force unless Congress gave them a standing army and navy and the like. That's still contested. I think we're clearly in a position where it's out of whack, where presidents have practically limitless power to use force, which I believe is dangerous because it means that one person who might or might not have good judgment and might or might not have good motivations decides the fate of the most consequential thing that can happen to a country, or among those things, of war. Coming up with limits is hard, both describing them normatively and how to enforce them. I would start by claiming that by putting, and I've written about this, by putting sharp constraints on so-called humanitarian interventions, including interventions of the sort that just happened. There may be a wonderful justification for this, but many of the people who were cheering on this war were not so cheerful when it was happening in Libya and Kosovo and vice versa. I believe that I don't know how this one is going to play out, but very often our humanitarian interventions end up making things worse rather than better. So I would draw the line there. But again, I'm talking about normatively. Operationalizing this is very hard. I would put further constraints on the president's offensive use of force. Right now, the president has claimed very extravagant uses of force. Congress would have to do a lot of work to limit that and to enforce those limits through appropriation limits. The president has constitutional self-defense power, and that self-defense power has been construed very broadly, and that's very hard to control. So those are the outlines of what I would do, but let me just say that the best way to ensure, given the realities of the American hegemon and this enormous military force that we have, the best guarantee of responsible uses of force is to elect prudent presidents.
Thank you.
I would like to jump in just very quickly. I think I might disagree slightly with Jack on portion of that. Insofar as we're talking about international law, which isn't really law, it's like the pirate code. It's more more suggestions than it is anything else. But there are norms, and international law, meaning international bodies and discussions among serious people, do have some normative pull. I'm not going to exaggerate how much, but at least some. But that pull, I believe, is entirely upon the good guys of the world. I think the powerful malefactors in the world will do whatever they want, and that the norms make zero difference to them. So whether the People's Republic of China attacks Taiwan or Russia tries to annex Ukraine, these questions are not going to be governed by norms. These are pure power politics. But I do think that the respectable nations of the world are affected by, not governed by, but affected by norms. And if the norm is that we don't engage in humanitarian interventions, but only in self-interested or self-defense interventions, that means that the norm we're embracing, if that's the norm, means we should not use force to protect populations around the world from tyranny, from oppression. But it's okay, or there is no norm against oppressing or invading because the bad guys are not affected by norms. I'm not sure, as long as we're in a world where gunslingers sling guns, I don't want to have a norm against having them sling guns in a good purpose. I think that might result in a slightly worse situation than what we're now in. But of course.
So I don't agree with that, but I'm not going to elaborate. I'll just ask this question. Do you think it's that China is more or less emboldened to invade Taiwan as a result of the invasion of Venezuela?
You're asking a graduate of, I didn't take that course in law school. It wasn't offered. I don't know. But if I had to guess, it's all realpolitik. And if I had to guess, I would say they're slightly less likely to invade Taiwan, not because of any norms, but because when the United States is aggressive, it gives them something else to worry about. And if we are very supine, they don't have much to worry about.
What I wanted to ask Juan, question of collateral issues, collateral consequences. The Wall Street Journal had discussed some collateral consequences in a recent article, said that the military or the preferred groups in the military get some of the oil revenues. The oil revenues from the state agency go to the military, and then the military parcels it out among the various buyers. And there's also cheap oil that goes to Cuba, which also supports the Cuban government, the military there. What's your feeling? You're a legislator in Congress in Venezuela. What's your feeling that this will enable change by cutting off this this money source, or is corruption too endemic?
There's not evidence that the military participate in the oil revenues in Venezuela. First, because the oil that goes to Cuba is for free. Even Cuba doesn't pay for that oil. Cuba just received that oil from 1999 during the Chavez time for free. Then also the business of the military and officers in the military is the business of drug trafficking. The cartel of the suns is a reality. Maduro was the head of that cartel, and it is called the cartel of the sun because of the sun that the officer, the general, uses as symbols. So I think that the control of the Venezuelan oil and to prevent Venezuela to send oil to Cuba or to North Korea has two purposes: to stop, to stop the revenues for the whole regime, and it is also a way to stop people from Iran who is in Venezuela running the oil company. And this led me to say something about Venezuela as an occupied country. Venezuela has already an invasion. It's an occupied country because the Russians are there, the Cubans are there, and people from Iran, Hezbollah, and Hamas are there in our country. We Venezuelans are not fighting just against the regime, but against the terrorism and against the dictatorial powers of the world.
Thank you.
Mr. Matheus, you're hoping for a free elections and a functioning constitution within the next 12 months. And let's say it's a perfect world and you get all the right people elected. But there is a court system out there that's filled, I imagine, with appointees of Maduro and so forth. And I just wondered how you would...
Excuse me, can you speak closer to the microphone, please?
Okay. My question is, say when you start the Constitution, you got good elected leaders, you still have a court system that's in place that were appointed by Maduro. How are you going to handle the judicial system in the new regime?
That is a pretty good question. When I was living in Stanford, working in Stanford back in 2019 and 2020, I started, along with Professor Diego Zambrano, a policy lab about the reform of the Venezuelan judiciary. And right now, we are talking to start something similar to that by the name of the judicial transition in Venezuela. And we have, in Venezuela, all the judiciary corrupt, not just the Supreme Court, the Supreme Tribunal, which is a political part of the regime. And that's the reason why we need elections, because we need elections to get a new parliament, a new democratic parliament, so that new democratic parliament could appoint the new justices of the Supreme Court and to draft a bill. We call that a law for the transition, the judicial transition, and I mean to restructure the judicial power in general. But it's a pretty good, interesting question. Actually, the Supreme Court gave an endorsement to Delcy Rodriguez to be the acting president of Venezuela, and of course that is illegal. They did it in an unconstitutional way.
Professor Lucas Gutentag.
Hi, excuse me. Hi, thank you very much. Thank you for this program. I wanted to ask Jack Goldsmith whether you could say a little bit more about the OLC opinion, the Bar OLC opinion, and in particular whether you wanted to say anything about your views on what a proper OLC opinion addressing those questions would look like, whether he got the law wrong, essentially, or whether the law is what it is, and he expressed it. But interesting, and also what you think it ought to be if you were in a position to write that OLC opinion. Thank you.
Sure. I mean, I basically think all of the opinion, and first of all, he was, the opinion overturned an earlier OLC opinion with which it disagreed, but it agreed with the earlier OLC opinion in some respects. I basically think that, well, first of all, let me say that every one of those propositions is going to be tested in court. So in terms of, do these criminal statutes apply extraterritorially? I believe that there's a powerful defense that they do. Is the president bound by customary international law, the non-written law of nations, in enforcing the law abroad? I think the answer to that is clearly no. Can U.S. enforcement agents enforce U.S. law abroad? I believe the answer to that question is yes, and we've been doing it for a long time. The hard question is whether the president is bound by the UN Charter, which the Supreme Court has subsequently said is a non-self-executing treaty. I think that was a very difficult question when Barr wrote that opinion. I think it's a much easier question now because of what the Supreme Court said in Medellin. So, I might write some sentences differently and make some different emphases and be a little bit more cautious. And he was cautious in places, but I think the opinion is defensible.
I have a question for Professor Goldsmith. One second. Just if you could actually just kind of expand on the last question, is there a kind of precise definition of a non-self-executing treaty, or is it just we signed this treaty but we don't really mean it?
That's not what a non-self-executing treaty means. So, but the answer is there a precise definition? Not really. I wish I had brought the Medellin opinion with me. The basic idea is that, the original idea is that a treaty is a contract between nations, and sometimes the treaty by its terms does not contemplate domestic enforcement. The treaty says this country will do this and this country will do that, and by its very terms it doesn't contemplate domestic enforcement. And Chief Justice Marshall drew this distinction in the early 19th century between a self-executing and a non-self-executing treaty because he said certain treaties just don't lend themselves to domestic enforcement. Okay. So it's not do we mean it or not. Whether, this is an important distinction in international law. A treaty is binding between nations on international law. The question of whether they're enforceable domestically is not really a question of international law. And usually. And different countries have different rules about how these international obligations get enforced domestically. This non-self-execution rule is the U.S. rule that's grown up over the last 200 years. So that much is clear. What counts as a non-self-executing treaty and how you tell what one is, the court has said different things about this, but it doesn't matter because the court said pretty clearly that the UN Charter, the Supreme Court said the UN Charter is a non-self-executing treaty. And in the same opinion where it said that, it said that that meant that the treaty did not count as, it basically said the treaty did not count as domestic law. And it said further that if the treaty is going to be implemented domestically, it has to be Congress that implements it through legislation. So, you know, I would not have written the opinion that way, but given that opinion, I believe that the government will have a powerful argument that the president is not bound by the UN Charter. So the case to read is Medellin if you want more guidance.
This event has a non-self-executing endpoint at 6. That's why we felt free to violate it. But please join me in thanking Jack Goldsmith and Juan Miguel Matheus for an extraordinarily informative session.